Hey everyone, my name is Jess and I'm here today to talk to you about the area of negligence concerning damages and defences. So damages are compensation. They are calculated based on a number of matters that the courts consider. So that includes a plaintiff's age, their lifestyle, what they could have earned in the future, any medical conditions that may have affected the seriousness of the injury, and so forth. So each case is assessed on the basis of their own individual facts and their circumstances and their situations. There's also a number of common law rulings that the courts need to follow in application, and also legislative provisions like the Civil Liabilities Act. So the defence of contributory negligence can be used by a defendant in response to a plaintiff claiming that they're responsible for a negligent act. Contributory negligence basically transfers some or all of the blame from the defendant back to the plaintiff. So it means that the plaintiff was somewhat liable for, part of the injury or the harm suffered, and that means any damages awarded will be reduced to reflect it. So there are two categories that potential plaintiffs can claim damages under. Special damages are calculated from the time of the actual incident until the date of trial. They're normally expenses that have already happened, so they can be calculated pretty accurately by the courts. Whereas general damages is a bit of a broader category because they are damages both financial and non-financial that can be calculated from the date of judgment until a date in the future. So normally it's like a retirement date or something. So general damages generally refer to expenses that have already incurred but that have not already been incurred, so can't be quantified, or they have to be relied on some kind of estimation by the court. So the two plaintiffs that we're talking about here that could possibly claim for damages are Ray Bands and Mick McDonald. So Ray, 62, he's got a pre-existing hip condition, so he knew that in a couple of years' time he would be required to have a hip replacement surgery anyway. The injuries he had from the explosion just meant that he needed to have that surgery earlier. He also had a favourite sport, lawn bowls, which he played regularly and participated in quite a lot. He was genuinely worried that he would not be able to return to the sport, but his doctors did assure him that he had an 85% chance of returning. So on the other hand, you've got Mick. So Mick was in his early 30s. So he was newly employed. So he'd been there for a less amount of time than Ray, and he was younger. But he'd impressed his bosses already. So he was in line for a promotion in the future, which meant that he'd probably get a raise. So his future earning potential was greater. He suffered a hand injury, which meant that he would not have any future working as a manual labourer ever again, which meant he wouldn't be able to have the promotion either. He could be found partially negligible because he failed to put on periprotective gloves that NOXO had recommended that he wear to protect himself. So of course Ray and Mick are very different in their situations. Ray would be able to claim for special damages and general damages. Special damages probably the cost of the hip replacement and reimbursement for any medical expenses incurred because of them. The courts would have to decide whether the eggshell skull rule was applicable here. If they did find that it could apply, then that would mean that the courts and the defendant would have to disregard Ray's previous injury, and they couldn't, rely on that to reduce the amount of compensation that they'd have to pay. But it's sort of unlikely here that it would actually apply, because Ray knew that the surgery that he would have to have because of the explosion, he would have had in a few years' time anyway, so there was that sort of element of foreseeability there. So it's sort of likely that, you know, maybe the award that he would have got would have like been reduced to sort of compensate for that. He'd also be able to receive damages for the funds he missed out on because of his unpaid leave entitlement, because, you know, he was eligible for time off, but it was unpaid, so the sort of wages he lost in that time he could claim for as special damages. General damages, future medical expenses related to the hip injury, any future lost earnings, but they'd be mitigated based on retirement age, and also compensation for you know, the potential of him not being able to return to lawn bowls. That would be mitigated by the doctor saying that he had an 85% chance of returning, but he probably would still receive compensation for loss of amenities. So Mick would also be able to claim for special damages relating to the injury to his hand, and any other medical costs that he would have incurred as a result. These related costs are all past expenses, so they're classed as special damages. More importantly, the most important future economic loss that he would have suffered would have been his future lost earning capacity. So this amount could not be quantified, so it would have to be assessed thoroughly by the courts and calculated through estimation and guesswork, really. So it would be considered a general damage. His future promotion would be taken into account, because it means that he could have been potentially earning more money because he would have received a raise when he had the promotion in the future. But it's important to note that any financial compensation for future losses will be mitigated by the provisions in Section 11 of the Civil Liability Act. Basically, that just caps the amount of damages that a plaintiff can claim. Damages awarded would also be reduced in consideration of any unforeseen future events that might occur that might affect Mick's working life. So obviously no one can really predict what happens in the future, and this reduction kind of accounts for things like if he took extended time off to go travelling, if he had another unexpected consequence that made him take time off work, like bereavement leave or paid parental leave or something like that. So moving on to convert. The facts associated with convert basically state that they intended to develop property on the land, and then they couldn't because it was contaminated by the water supply was contaminated. And at the time of the contamination, they had gathered all the information ready to submit an application for approval, but they hadn't actually submitted it yet. So we know that pure economic loss is compensable harm, and it means that the plaintiff can receive damages for, you know, future lost revenue. Convert would have to provide solid evidence that they did have a lost opportunity here. In other words, they lost the chance of a better outcome because they weren't actually given the chance to develop, because after the explosion, that idea was shelved anyway. In order to succeed in prosecuting Noxo for the pure economic loss, they would have to present evidence, like on the balance of probabilities, that there was a strong likelihood that had the planning permission been accepted, then the building work would have gone ahead. So they would have to provide a lot of supporting documentation to prove this. So all the application forms and documents that they were getting ready to submit, any other building plans, survey reports, anything related to the land in question, that would have sort of given evidence that had the explosion not happened and the application been approved, that that they would have gone ahead with the building development and potentially made a lot of money. If they could do this, then they would have a case for compensable harm and pure economic loss, and they could be awarded damages to compensate for the income lost. So, sort of going back to the injury that Mick suffered, NOXO may use contributory negligence as an offence to try and reduce the amount of compensation that they owe them, by trying to prove that Mick was, partially liable for the injuries suffered. Before the Law Reform Act came out in 1947, had a legislative solution. If a defendant had proven contributory negligence on behalf of a plaintiff, then it was a 100% defence. So that meant that there was no case, basically. So it was kind of really heavy on the defendant and not really fair on the plaintiff. So that's why the legislation came out, sort of to counteract that, I suppose. The most important consideration in Mick's case was the fact that his colleagues had asserted that he'd been drinking alcohol during the working day. So Mick had himself said that he had a drink but only had 1 pint. It's really difficult because you don't know how many units of alcohol is going to affect someone's judgment. So the amount that he had to drink is kind of immaterial, really, because we can't really prove how many pints it would take for Mick's judgment to get severely affected. In the Civil Liability Act, it's quite heavy on intoxication and negligence. If a plaintiff is found to be, to have had their judgment affected by alcohol or alcohol consumption, it's sort of up to them to prove that their alcohol intake had nothing to do with their failure to protect themselves. So onus is really on them to prove it. The only kind of defence to that is if someone had involuntarily consumed alcohol, which Mick wouldn't have done, probably. So going forward to him not wearing the protective gloves, the fact that they were kind of recommended versus required doesn't really have much emphasis here, because there has been evidence in the case where Mick has worn them previously because he knew that they would protect his hands. So I guess by him not wearing them, it sort of shows that he kind of failed to mitigate the seriousness of the injury. If he'd worn them, the injury wouldn't have been as serious as it was. So it's likely that NOXO would be successful in proving that Mick was partially liable for how serious his injuries were, because had he worn the gloves, then he probably wouldn't have had as severe harm suffered as he did otherwise. In conclusion, it's pretty obvious that Ray and Mick will be able to claim damages, both special and general, due to the explosion, but all sort of the damages awarded will be reduced or mitigated in some way to sort of account for their own personal circumstances. When there's a case of convert, it's highly likely that they would have a case for sort of pure economic loss, as long as they kind of did their due diligence in submitting all their documentation to kind of prove that had the explosion not happened, then the application would have been approved and they would have been able to develop on the land. In the case of Mick and contributory negligence, it's likely that NOXO would be able to use it as a defence, primarily due to Mick sort of admitting that he'd had a pint at lunch, and with the Civil Liability Act not seeing too kindly to negligence and intoxication. So it's likely that he'd still get sort of compensation for injuries, but they'd be mitigated due to his his drinking and his failure to protect himself. And that's everything for today. Thanks so much for listening, everybody. See ya.